The UK senior worker or specialist worker route was born on 11th of April 2022 as all other global business mobility routes. This is a replacement of the old intra-company transfer route, which was officially called Tier 2 intra-company transfer long-term staff work visa. So this particular route is for managers and specialist workers where the employer asks them to oversee a business here in the UK where their UK business is connected with the overseas business. So in this particular video, I'm going to explain what three requirements the applicants under this route will need to satisfy in order to succeed in the application, whether or not they can invite their dependents, and whether or not they can settle when applying under this route. So in other words, whether or not they can apply for indefinite leave to remain. So let us begin. Okay guys, in order for you to succeed in your senior or specialist worker visa, you need to satisfy three requirements: the validity requirements, the suitability requirements, and the eligibility requirements. Let us have a look at the validity requirements first. We can subdivide the validity requirements into two parts. The first one is all applicants will need to comply with the procedural parts, and secondly, the switching rules, which will apply if you're applying from the UK. The procedure is very, very simple. It consists of 5 steps. First of all, there are 2 application forms. The first one is if you're applying from outside the UK, you'll need to complete the form, which is called Global Business Mobility Visa. And if someone applies from the UK, then it's going to be Global Business Mobility without the word visa. Of course, all applicants will need to pay the fee, and the fee will vary on the type of the application. So if you're applying from outside the UK, then you're making an entry clearance application. If your visa is going to be for less than 3 years, then the application fee is £625. If it's for more than 3 years, then the application fee is £1,235. For those who apply in the UK, again, the fee will depend on how long you intend to stay here in the UK. If you would like to stay here for up to 3 years, then you'll need to pay a fee of £719. And if it's for more than 3 years, then it's £1,423. And of course, all applicants will need to pay the immigration health surcharge. All adults above 18 years old, so if you're not applying as a dependent, will need to pay a fee of £624 per year. So if someone wants to stay here for 3 years, you'll need to multiply £624 by 3. If someone applies as a dependent of the senior specialist worker, then they will need to pay a reduced fee of £470. The applicants will need to confirm their identity and nationality and their age, and this can be done with the help of producing a passport. Just to remind you that all applicants will have to be over the age of 18, and unfortunately the IDs are no longer acceptable with the applications. The next step is to submit your biometrics, and finally, if you're applying from outside the UK, you'll need to check if you need to submit your tuberculosis test certificate with the application. And let me show you how you can do this. So if you go to your browser and you type Appendix T, the first link which you will see is this one, the .gov.uk link. So this is our Appendix T, and here you'll see a list of all the countries where the residents will be required to submit their tuberculosis test certificate together with the application. And if you are not a national of this country, but you have been residing in this country for more than 6 months, you'll need to submit the certificate confirming that you have taken the tuberculosis test. And if you are a national of one of these countries, but you have been residing in another country which is not on this list, if you have been doing so for less than 6 months, again, you'll need to submit a test certificate. But if you have been residing in the country, despite the fact that you are national of one of these countries, but you have been residing in another country which is not on this list, then you don't need to submit a test certificate if you have been doing so for more than 6 months. And this was our procedural part. Also, if you're submitting your application in the UK, you have to remember the switching rules and you have to make sure that those don't apply to you. What is switching? Switching is a legal process which allows the applicants who are already in the UK to switch from one immigration category to another. So let's say someone came here as a student and they were issued with a student visa, and then they got married. So they married a British citizen and they applied as a spouse of a British citizen. So when they did so, they switched. So they switched from one immigration category to another. So if you are applying, let's say as a student, and you would like to extend your visa here as a student, then you're not switching because you're not changing immigration categories. You're only extending your stay. However, if you're changing immigration categories, then you will be switching. So if you are in the UK and you would like to make this application, but you stay here as a visitor or as a short-term student or as a parent of a child student or as a seasonal worker, as a domestic worker in a private household, or you made your application outside the immigration rules, unfortunately, you will not be able to switch to this immigration category. And if, guys, you are in one of these categories, this means that you will be expected to leave the country and make an entry clearance application. So you'll need to apply from outside the UK. If you meet all these validity requirements, if you follow the correct procedure, and if these switching rules don't apply to you, this means that you have met the validity requirements. After the decision maker checks that you met the validity requirements, they will proceed to the next stage of checking whether or not you meet the suitability requirements. In very simple terms, the suitability requirements is all about the applicant proving that they are of good character. In order for you to check if you meet the suitability requirements and you're applying from outside the UK, you need to check whether or not any provisions of Part 9 of the immigration rules apply to you. And if you are applying from the UK, then in addition to meeting Part 9, you'll also need to meet the requirements of paragraph 39E of the immigration rules, and you'll need to ensure that you are not on immigration bail. So let me show you how you can find Part 9. So if you go to your browser and you type Part 9 immigration rules, the .gov.uk website is the one you need, and here, as you can see, there are grounds for refusal. Just to draw your attention that there are two types of suitability requirements: mandatory and discretionary. If you're caught by one of the mandatory grounds for refusal, this means that the decision maker has no choice and will need to refuse your application. If any of the discretionary grounds for refusal applies to you, then this means that the decision maker has a choice and they can either allow or refuse your application. And the way you can differentiate between the two grounds is very simple. If you check the wording of the grounds for refusal and you'll see the word must, then this means that this is a mandatory ground for refusal. So, for example, if this section 9.2.1 applies to you, then unfortunately the decision maker has no choice and they have to refuse your application. So if you have a exclusion or deportation order which is still enforced, then this means that the Secretary of State will refuse your application. If a criminality section applies to you, then this means that the decision maker again will refuse your application. And let me give you an example of one of the discretionary grounds for refusal. Okay, for example, this one, paragraph 9.9.1. So if you failed to attend an interview or provide some information with the application or provide your biometrics, the application may be refused. So this means that the decision maker has got a choice and they can either allow or refuse the application. There are quite a few suitability requirements, but generally when the decision makers check this part, they'll want to ensure that you don't have any exclusions or deportation orders. They'll also be checking your criminal convictions, whether or not you were excluded for asylum or humanitarian protection, involved in any sham marriages, you made any false representations when submitting your previous applications or when submitting this application, whether or not you breached immigration laws, failed to provide any requested information, or whether or not you have any debts to NHS or unpaid litigation costs to the Home Office. Guys, as I said, if any of the provisions apply to you, it doesn't mean that the application will be refused straight away. It depends on whether or not this is a mandatory or discretionary ground for refusal. If it is a discretionary ground for refusal, before applying, I strongly suggest that you take steps in order to make sure that you rectify the situation and to make sure that it doesn't apply to you. Paragraph 39E is a very simple one to understand. This is provision for those who overstayed where their visa already expired. So paragraph 39E explains that if you became an overstayer, let's say you don't have a valid visa, this will be disregarded if you made your next application, your next visa application within 14 days, and you also provided evidence confirming that there were good reasons for you not submitting your application within the time limit. So these were our suitability requirements. After checking that you meet the validity requirements and the suitability requirements, the decision maker will proceed to the next step, and they will be checking if you meet the eligibility requirements. The eligibility requirements, because this is a points-based system application, they consist of two parts. The first one is the points-based requirements, where the applicants will need to prove that they can score 60 points, and you will need to meet the non-points-based requirements. So let me show you how you can meet the points-based requirements. All applicants will need to score 60 points, 20 points for the sponsorship, another 20 points for proving that their job is at an appropriate skill level, and finally, they will need to show that their salary is at the required level, and for this, they will be able to score another 20 points. In order for someone to meet the sponsorship requirements, they will need to provide a certificate of sponsorship, which should not be older than 3 months at the date of the application. And there are a number of things which should be mentioned on this certificate of sponsorship. First of all, at the date of the application, this certificate of sponsorship will still need to be valid, so no longer than 3 months, not withdrawn by the sponsor and not cancelled by the Home Office. And also, this certificate of sponsorship will need to confirm your name and also the fact that you are being sponsored as a senior or specialist worker, the details of your job, salary, and any allowances that the sponsor is offering you, your pay details, when you intend to start your job, and also unless you're applying as a high earner is someone who will be earning more than £73,900 a year. You'll also need to prove that you have been working overseas for the company outside the UK for a cumulative period of at least 12 months. If you're applying as a high earner, it doesn't really matter how long you've been with this company. And finally, if Appendix ATAS applies to you, then you'll also need to submit the ATS certificates with the application. The next element of the sponsorship requirement is for the sponsor to prove that they were A-rated by the Home Office, registered and licensed and authorized to invite applicants as senior or specialist workers. And also they'll need to prove that they paid the immigration skills charge. Here's how much they will need to pay. So if the sponsor is a small or charitable sponsor, in the first 12 months, they'll need to pay this amount, £364. And for each additional month, that's going to be £182. And for all other companies, it's £1,000 for the first 12 months and then £500 for each additional 6 months. And how can you say if a company is a small company or it's a charitable organization? So guys, your sponsor is a small sponsor if at least 2 of the following conditions apply. So the first one is when the sponsor's annual turnover is 10.2 million or less. And the second one is when the sponsor's total assets are worth 5.1 million or less. And finally, if the sponsor employs 50 employees or less. So if any of these 2 conditions apply, then this means that the sponsor will be categorized as a small one. With regards to the charitable sponsor, they will need to be registered as a charity in England or Wales or Scotland or Northern Ireland, or they were registered as an accepted charity, exempt charity, or as an organization established for charitable purposes. The next element of the sponsorship requirement is the genuineness element. So when the applicants submit the applications, first of all, the decision maker will be checking that this job does exist and there is a need for this job, and also that the sponsor complies with the third-party requirements. So in other words, you'll need to prove that you are not being sponsored to hire your services to a third party, to fill a position with that party, whether temporarily or permanently. And secondly, that you have no intention of undertaking an ongoing routine role or to provide an ongoing routine services to a third party, regardless of the nature or length of any arrangements between the sponsor and the third party. And finally, as I said before, unless you're applying as a high earner, you'll need to prove that you have been working overseas for this sponsor for the company for at least 12 months. And if you interrupted your employment because of maternity, paternity, parental or shared parental leave, or if you had a statutory adoption leave, or if you were on a sick leave, or assisting with a national or international humanitarian or environmental crisis with the agreements of the sponsor group, or if you were taking part in illegally organized industrial actions, this will not interrupt the continuity of your employment. So if all of these elements were satisfied, then this means you'd be able to score 20 points for the sponsorship. The next 20 points will be given to you if you prove that your job is at the appropriate skill level, and all you have to do to prove that is your job is listed at appendix skilled occupations for the global business mobility route, unless you're applying in one of these categories, unless you're applying as an artist or as an author or writer or translator, as an actor, entertainer or presenter, dancer or choreographers, or if you're applying as a product clothing or a related designer. So if you apply in any of these categories, you don't need to prove that your job is listed at appendix skilled occupations. Also, the decision makers will be checking that the code which your sponsor gave in the certificate of sponsorship is the most appropriate one for your job. And the decision maker will refuse the application if they had grounds to believe that the most appropriate occupation code is not eligible under the global business mobility route, or the most appropriate occupation code has a higher going rate than your proposed salary. So these were our 20 points for the job at an appropriate skill level requirement. And finally, you have to meet the salary at the required level requirements in order to score the last 20 points. So the salary will need to be at least £42,400. For the purposes of checking whether or not you meet these particular requirements, they will be checking how many hours you intend to work. If you intend to work more than 48 hours a week, and even though it is stated on your contract, they will only take into consideration the first 48 hours and they will disregard the rest. With regards to the going rate requirements, the going rate is the minimum salary a person should expect to receive if they are employed to do a particular job. And let me show you how you can check the going rates for your occupations. So if you go to your browser and you insert Global Business Mobility Going Rates, the first .gov.uk website is the one you need. And as you can see, we have the going rates for the senior or specialist workers, and also those who would like to apply here as UK expansion workers. So these are the going rates. And this is the column which you need to check, the first one, because you're not applying as a graduate trainee. You'll be applying as a senior or specialist workers. So these are the going rates. So in addition to proving that your salary is going to be at least £42,400 gross a year, you also need to show that, let's say, if you'd like to work as a senior police officer, your salary will need to be at least £52,000 a year. So these were our points-based requirements. Once again, just to summarize, you'll need to score 20 points for the sponsorship, 20 points for job at an appropriate skill level, and finally 20 points for salary at the required level. And the next one is non-points-based requirements. We have the financial requirements, and also the next one is the maximum length of assignments requirements. The financial requirements: if you are already in the UK and you have been in the UK for more than 12 months, these financial requirements will be met automatically, or also if your A-rated, registered and licensed sponsor intends to cover your expenses for the first months and they reflect this information in their certificate of sponsorship, this means that this particular requirement is was met automatically. For all other applicants, they'll need to show that they have at least £1,270 in their bank account, and this amount was in their bank account for at least 28 consecutive dates. And another non-points-based requirement which all applicants will need to meet is the maximum length of the assignment requirement. So this means that the applicants in this category can remain in the UK for only a certain period of time. If you're not applying as high earners and they're extending their stay, the total number of years which they can remain in this immigration category as the UK senior specialist workers should not exceed 5 years in any 6-year period of time. If someone applies as a high earner, then they should not remain in the UK for more than 9 years in any 10-year period of time. And another point to bear in mind, guys, is that they will be taking into consideration the time which you spent in one of these immigration categories. So if you remained here before as an intra-company graduate trainee, or if you stayed here on a graduate trainee visa or as a secondment worker, they will be adding this to their calculations when considering whether or not you meet the maximum length of the assignment requirements. So if you met all the validity, the suitability and the eligibility requirements, your application will be granted. If the application was refused, unfortunately, there is not going to be a right of appeal. You will only be able to apply for an administrative review. With regards to the duration of your visa, we already discussed this point. So if you're applying for the first time, the maximum length of your visa is going to be up to 5 years, or for the amount of time which is stated on your certificate of sponsorship plus 14 days. So let's say on this certificate of sponsorship, your employer mentioned that they only want you to work here for 3 years. So it's going to be the duration of your visa is going to be for 3 years and 14 days. If they want you for 6 years, the maximum length of your visa is going to be only 5 years. For high earners, the rules are slightly different, so they can stay here for a maximum period of 9 years in any 10-year period of time. As I said before, you can only stay here for a maximum period of 5 years in any 6-year period of time. There will be certain conditions imposed on your stay, so you will be allowed to work only for the sponsor who issued you with the certificate of sponsorship. You will be allowed to study. You can invite your spouse and children under the age of 18, those who are dependent on you and those who do not lead an independent life. You can volunteer and you can travel abroad as many times as you want to. You will not be allowed to claim benefits. However, some exceptions apply here. You cannot work for anyone else but only your employer, and unfortunately this route is not a route to settlement, so you will not be able to apply for indefinite leave to remain.